Hello, everyone. Happy Monday. Happy Martin Luther King Jr. Day today. I'm coming to you live with a special broadcast, very, very special broadcast, breaking down the Scotus, breaking down specifically the Scotus decisions that came out last week, last Thursday, much to many people's delight as well as dismay. And I'm going to talk to you about that, why there was this sort of split. We had, on the one hand, a very, very positive decision, the High Court striking down the Biden OSHA mandate. But then on the other hand, we had a very disappointing decision in that we had the CMS mandate, the healthcare workers mandate being upheld. And so how really is the question. How could the same justices, the same court, by a majority vote, find that the OSHA mandate was bad and was illegal, or that the stay should be implemented, is really what they found. And then on the healthcare workers mandate, find that no, it should not be stayed. That's a very legitimate question. It's a valid question. And so a lot of people have reached out with questions. And so that's why I figured I would take the time to speak with you tonight to sort of break this down a little bit. And I want to give it another minute or so as people are hopping on. I see the number of viewers ticking up. So I want to give people enough time to tune in. It is just 7:01 p.m. I said this would start at 7, so I wanted to come on the air promptly. But by the same token, I want to give enough people a chance to tune in who may want to at this point. So we'll wait, like I said, just a little bit longer before we really get into the meat of this. Like I said, I know that people are concerned, are rightfully so, concerned about the healthcare workers mandate and why that is allowed to persist. And I want to spend time tonight, really most of the time, responding to your questions. I don't want this to be an incredibly long broadcast. I want to just quickly give an overview, break down why the court ruled the way that it did. And then after I do that, I want to give you a chance to chime in with questions. So we do have comments. If you're watching on YouTube, you can post a comment, and I should be able to see it right there. If you're watching on Facebook or Twitter, same thing. You should be able to post a comment and it will come up. I have a banner on the right hand side of my screen where I can see comments in real time as they're coming in, and I can even post them to the screen and then respond to them. So, all right, well, let's jump into it. The first decision was the good decision, we'll say, the decision to grant the stay of the OSHA mandate. And so let's talk about what that decision said and why it was granted. So OSHA is a federal agency under the Occupational Safety and Hazards Act. It's granted broad power by Congress to regulate workplace safety. All right. That's the key phrase here. The key word actually is workplace safety. Never before has it been granted broad public health authority to regulate safety and health both inside and outside of the workplace. And that's exactly what this mandate, this Biden mandate, this OSHA mandate at the behest of Biden, sought to do. It sought to regulate someone's health, someone's safety. Again, I'm using the air quotes on purpose. You'll know why. Both inside the workplace and outside the workplace. Because as the majority opinion put it, a vaccination, getting jabbed, isn't something that you can leave at the door of the workplace, that you can, shed it when you're going home. Well, you do shed it, actually. We can talk about that another time. But it's not something you can just take off and set aside and leave at the workplace door and say, okay, well, now I'm going home and now I'm not jabbed anymore. I'm only jabbed when I'm in the workplace. No, it affects you both inside and outside of the workplace. It affects you everywhere. And so they're basically attempting to regulate your health, regulate public health everywhere, and not just in the workplace, which clearly goes beyond their statutory grant of authority. Now, some of you will say, well, OSHA shouldn't even have the authority it has. That, there's nothing in the Constitution that says that there's these regulatory agencies that can decide, make all of these decisions and regulate everything that goes on in a private workplace. No, there's nothing explicit. There is something called the Commerce Clause, and the Supreme Court has previously ruled that Congress, under the Commerce Clause, which is to regulate interstate commerce, supposed to be just to regulate that, also has the authority to regulate things that affect commerce. So not only the sort of instruments and instrumentalities of commerce, but also things that have an effect on commerce, such as obviously workplaces have an effect on commerce. You're talking about what commerce is. Obviously, that's doing business, transacting business, and workplaces transact business. And so this is something that's going to affect commerce. Obviously, if you have tons of people being sick or being harmed in the workplace, that would have an effect on commerce. So that's been settled by the Supreme Court precedent. We're not going to win a case saying that OSHA shouldn't even exist to begin with, that OSHA doesn't even have any authority. The Constitution doesn't grant Congress the authority to even create these federal agencies. That's already been decided long ago, long line of precedent. You're not going to win a case. Simply, you might have legitimate constitutional arguments, but now is not the time to be bringing those and be losing cases when workplace safety and workers' safety, the safety and health of individuals and their religions is at stake. And what do I mean by that? I don't mean workplace safety is jeopardized by COVID. I mean by forcibly injecting people with this foreign substance, which, as we all know, in many cases is toxic, even deadly. We have evidence. This isn't coming from me. I'm not a doctor or scientist, but we have a long line out the door of doctors and scientists that can show you the evidence. Is very clear evidence that there's real risk, significant, substantial risk to someone's health by getting this injection, getting this shot. So we have to be very careful that people's lives are at stake. We don't want to be making these broad constitutional arguments trying to do away with OSHA just because that's what we feel and that's what we may believe, okay, that we want to take some constitutional stand when that's not going to win the case. That's going to get the case thrown out in a heartbeat. Okay, so we have to be smart about this. Although we want to make those arguments, this isn't the time to be doing it. This isn't the time or place when millions of people are at risk of losing not only their jobs, but their lives over this. So we don't want to do that. So the court agreed that this was going way beyond Congress's grant of authority to OSHA. It never had before has done this. Historically, it's never done this. There's something called the Major Questions Doctrine and the Non-Delegation Doctrines. They're discussed very eloquently in Justice Gorsuch's hard to say, concurring opinion. The concurring opinion is he's agreeing with the court. He ruled with the majority. He was one of the justices that ruled with the majority, but he wanted to write his own separate opinion in agreement, but making some different points maybe the majority didn't make. So the non-delegation doctrine and the major questions doctrine basically are just saying that, these major powers, broad sweeping powers can't be delegated to unelected officials. Congress is elected by the people. And so they're vested with making those broad policy decisions, such as public health decisions. And again, people are going to dispute that and say the Constitution doesn't give them that authority. But still, if it's going to be a major, far-reaching question, if it's going to be something that is reserved for elected officials as representatives of the people in our republic, they're supposed to be representing us because we voted them in. You can't delegate that to these unelected officials in these agencies and say, well, let them figure it out, let them handle it, give the power basically to them, the power that's reserved to the people through their elected officials, and be delegating it to these unelected officials like the head of OSHA or something. You can't do that. Okay. And so that's very important. And so that also was a reason that this stay was upheld and was imposed. Justice Gorsuch actually had something very important too, besides that he said in his concurring opinion. So a lot of people, when this decision came out, became afraid and said, but doesn't that mean, and actually there was even some journalists, there were some journalists that were even writing, yeah, but doesn't this mean that, Congress can just go back and give them that authority and then that'll be okay, as long as because they didn't explicitly do it. There's nothing granting them this authority, but if they just go back and pass, a law saying that OSHA has this authority, then that'll close this loophole and then it'll be upheld by the court, but not so fast. Again, can't delegate a power that was never intended to be given to this agency, that kind of broad public health authority that's going to affect them both inside and outside the workplace. And as Justice Gorsuch says, I just want to actually read it to you, if I may. I was going to put it up on the screen, but I'll just read it to you. I think it'll be quicker for me to do that than to mess with technology that I'm not always adept at. It says, whichever the doctrine, again, meaning the non-delegation doctrine or the major questions doctrine, whichever the doctrine, the point is the same. Both serve to prevent government by bureaucracy, supplanting government by the people. That's a quote from the late Antonin Scalia, actually, Justice Scalia. And both hold their lessons for today's case. On the one hand, OSHA claims the power to issue a nationwide mandate on a major question, but cannot trace its authority to do so to any clear congressional mandate. On the other hand, if the statutory subsection the agency cites really did endow OSHA with the power it asserts, that law would likely constitute an unconstitutional delegation of legislative authority. That is extremely telling, because what he's saying is, even if they try to do this, even if Congress did try to grant OSHA this authority, it would likely constitute an unconstitutional delegation of legislative authority, again, under both of these doctrines or either of them, and therefore it wouldn't be upheld anyway, most likely by this court. So again, that flies in the face of what some of these journalists and some of these pundits were saying after this decision came out, that, oh no, this is going to be horrible, even if even though the stay was upheld, they can just go back and give this authority to OSHA. Gorsuch says, not so fast. That's probably not going to be upheld as constitutional. So go ahead, you can go ahead and do it, but it's not going to work. It's still going to be struck down. So I do believe this is going to be permanent. Right now, it's technically not a permanent decision. So what a stay or a preliminary injunction is it places a hold on the mandate from going into effect while the litigation plays out. So in this case, it goes back to the Sixth Circuit. It'll continue to be litigated, and then they can apply for review, certiorari. It's called a writ of certiorari to, or cert, they call it for short, to the United States Supreme Court to decide, again, on the merits of the underlying case. But they've already said, one of the prongs to grant an emergency stay, is to say, or a preliminary injunction, is whether or not the plaintiffs are likely to succeed on the merits. And because the majority of the justices feel that this was basically an overreach, an unconstitutional and illegal grant of authority, they're tipping their hand as to how they'll rule when the whole case comes before them. So even if after the Sixth Circuit hears this fully on the merits and it goes back up to the Supreme Court, they're likely to rule the same way. It's not likely to change anything. They've basically already said that we're gonna rule the same way. For all intents and purposes, they've said that without saying it. And so this stay remains in place until a final decision is issued, and either the writ of cert is denied, and then that means it becomes final. There's no more appeals. Or if it's granted, it stays in place until the Supreme Court issues their final decision. So in my opinion, the OSHA, the OSHA mandate is dead. It's not coming back. It's going to be permanent, although technically it's not. It's just temporary while the litigation plays out. In my opinion, it's going to be permanent. All right, when the dust settles. Now, what about the CMS mandate? Well, again, the very same court that ruled that the OSHA mandate was too broad ruled differently in the CMS mandate. So CMS is for Medicare and Medicaid funding facilities that receive that funding. There was a mandate that says if you receive, the Secretary of Health and Human Services enacted this mandate, again, pursuant to Biden, the executive branch, not Congress, that if you receive funding for Medicare or Medicaid, then if any facilities that receive that, which is almost all facilities, then in that case, you must have your staff receive the COVID shot. You must have that mandate in place. Otherwise, you're going to lose that funding. And that would be huge. That'd be devastating. I mean, most of these facilities couldn't operate. Pretty much all of them couldn't operate without that funding. This is the problem with becoming dependent on big government, becoming dependent on their funding, because now they can basically coerce you into doing anything, right? Because they hold the purse strings. So if they say, you do this or else we take your money away, your business is gone. So you really don't have much of a choice. There are some, administrators or owners of these healthcare facilities that probably don't agree with the mandate, that are like us and say this is wrong. But if I don't go along with it, I lose my business. I'm done. I lose everything. I have to fire everyone and shut my doors, and all these patients go without care. So what do I do? And so they sued, some of them sued, and these states sued as well on behalf of them. And so there were, this is how we got where we are at the United States Supreme Court on this emergency application for a stay. Unfortunately, in this case, the application for a stay is denied now. And why? Why did Roberts and Kavanagh, Justices Roberts and Kavanagh, who ruled with us on the Osha decision, why did they now flip and rule with the three so-called liberal justices, Breyer, Sotomayor, and Kagan? Why did it flip now from a 6-3 decision to a 6-3 decision in our favor to a 6-3 decision against us now? That's a curious question, but when you read the decision, their justification is that, well, we're talking about healthcare facilities. We're talking about places where, there's a high risk of people becoming ill, that the safety of patients is paramount. This is what the Secretary of Health and Human Services is granted the statutory authority to do, is to keep, patients safe in healthcare facilities, safe from hazards, that could make them very ill or could kill them. Now, we know the opposite is true. By pushing these mandates, you're actually placing the risk. You're not doing really much of anything to improve patient safety. What you're doing actually is risking the health and safety of the workers, so much so that you're going to have staffing shortages, not only by people refusing the shot, but from people who are injured by the shot or worse. This is discussed to a degree in the opinion. They don't buy that argument. They say that it's still, the risk-benefit analysis. There's much more of a risk by not having the staff jabbed than there is having them jabbed. So, in their opinion, because these are healthcare facilities, that changes things somehow. That changes the equation, because now you're dealing with life or death situations. And even in the OSHA decision, they did kind of hint at this. They said, well, that's part of the reason why they struck down the OSHA mandate. Is they said, well, they granted the stay. Technically, they didn't strike it down, but for all intents and purposes, like I said, they did. They said the OSHA was too broad. The OSHA mandate, it was just 100 or more employees. Any company with 100 or more employees that applied to it. It wasn't specific to places where there was a real risk of contracting COVID, such as, they said, laboratories where you're working with the virus, or healthcare facilities, where there might be an increased risk of transmission. So they did kind of hint at this. So we really shouldn't have been surprised when you read the OSHA decision first that, they're kind of going there saying that, if this were a high risk situation, if it was limited just to high risk, if the mandate were limited just to high risk areas and facilities, then it would have been okay. That's dangerous. And you see that surface then in the CMS decision. And so, they bought the COVID lies. We know what the real data shows. We know that these shots, I don't use the V word when I refer to them. These shots, these jabs, are neither safe nor effective. But basically, the Secretary of Health and Human Services, they said, was reasonably relying on the consensus, on the data. Again, it goes back to the consensus. And they even cited that in the majority opinion, that since the majority of doctors and healthcare professionals agree that the mandate is good and is necessary in healthcare facilities, that alone it shows that the secretary's actions were reasonable and were justified. Because look how many doctors agree with them. It must be true then, right? So this idea of consensus, again, this is why it's going to be very hard for us to win on the science in court, and why our organization, We the Patriots USA, is stuck to religious liberty primarily. And people get angry sometimes, even write to us, why don't you attack the science and prove that this is wrong? They're not going to listen to it, folks. They're not going to listen to it, folks. When you have 6-3 majority buying into the lies that are told by the mainstream media of the United States Supreme Court justices, you're beating your head up against a wall. When you have Justice Sonia Sotomayor in the oral arguments for these cases actually saying that there's 100,000 children in America on vents because of on ventilators because of Omicron, which is completely false. You're beating your head against the wall. You think you're going to convince them that that this is not as deadly a virus as the media is portraying, or that the shots don't work or aren't effective? You're beating your head against a wall. That's not the way we win this. We win this by showing it's unconstitutional. And I believe ultimately we will be able to show that. We have a New York healthcare workers case, okay, that we are bringing. We have brought, actually, it's already gone to the Supreme Court. It's now back at the district court. And we're continuing to argue this, or it'll be at the Second Circuit. And then, very soon, we believe we'll be back at the United States Supreme Court. This is the New York healthcare workers lawsuit where the state of New York said you're not even allowed to request a religious exemption. At least with the CMS mandate, you are actually allowed to get religious exemptions. The state of New York said no religious exemptions at all. And so we want to preserve religious liberty that, okay, regardless of what you think about the shot, about how safe or effective, or what you think about COVID, these workers should have religious liberty, should be able to opt out. And so we intend to prove that and intend to win that case at the United States Supreme Court. So again, they unfortunately saw the CMS mandate very, very differently, because they looked at it from the perspective of this is a grave danger to public health. This is was within Congress's grant of authority. And so because of this, it was justified. Justices Thomas, Alito, and Gorsuch wrote a wonderful Justice Thomas wrote a dissenting opinion. He wrote a dissenting opinion. Alito wrote his own dissenting opinion, but he had joined Justice Thomas's decision as well, really saying that no, this goes way beyond the authority that they should have, that Congress ever intended to grant. For you're talking about obviously a public health crisis, unlike we've ever seen before. That's, the talking point. And, you can debate whether that's true or not, but they're trying to justify this by saying, okay, well, this is so much worse that the secretary, yes, he's never done this before, never enacted this kind of a mandate as broad sweeping, but it's okay because, again, we're dealing with healthcare facilities. But they really only pulled it. And so Gorsuch and Alito talk about this. Justice Thomas talks about this. They really only pulled it from one definition in the regulation talking about long-term care facilities. All right. That, so they're saying that because there's this authority supposedly for enacting this vaccination mandate for long-term care facilities, that gave the secretary the authority. But the problem is the secretary of Health and Human Services took the authority way beyond that, not just for long-term care facilities, but for every kind of healthcare facilities, even outpatient physical therapy facilities are subject to this mandate. So it went way beyond the statutory grant. But that's not how, the majority saw it in this case. Saw it very differently in saying that, well, again, this is public health and we have to treat this, very seriously. And they also refer to the fact that, healthcare workers for years have been mandated to get things like flu shots and shots for measles, mumps, rubella, Hep B even. There's a variety of shots that healthcare workers have been required to get. And, maybe, yes, they didn't have this broad federal mandate in the past, but they didn't need to because pretty much every state requires that of its healthcare workers, which is true. But this is the problem, folks, with bad precedent, because now we allowed that, and that was bad precedent. We never should have allowed it. And it was tied also to Medicare and Medicaid funding. These facilities had to have flu shots, had to have all of their staff or most of their staff get the flu shot, or else they would lose funding. It happened before, and we allowed them to get away with it. And so now, look, they're using it for this against us. And the majority does use it against us. They say, well, look, it's been allowed. It's been allowed in the past. This isn't something new. It isn't some broad overreach. Everybody's been fine with it all this time, even though we weren't really fine with it. But it seems like it because we didn't bring a challenge and win any lawsuits. We, back then, our organization didn't even exist. But I'm not talking specifically about We the Patriots, but we people that are opposed to such mandates didn't bring the lawsuits and didn't win them. So there's no precedent really to say there's anything wrong with that. So why is there anything wrong with this? And that's the danger. that you get into when you have that. I'm sorry, I got my son here, but that's the danger you get into when you have that kind of bad precedent. All right, that all of a sudden now that becomes the law of the land. That becomes the new normal, and people are okay with it. And this is why we have to be very, very careful. And this is why I keep telling people we are in a race right now. We are in a race against the bad precedent, a race to the courts, and we can't wait for this funding to come in. We cannot just wait years and, hopefully our organization will be fully funded in 5 years, 10 years, and then we'll bring those lawsuits. It's going to be too late, folks. It's going to be all said and done. We're going to have the bad precedent on the books. This is the new normal. Vaccinate forever, everyone. Okay. And that will be the mandate. And your children in school forever will have to get the COVID shot and boosters. All children, K through 12. All right. That will be the new normal if we don't win these lawsuits. We need to be funded. We need to be funded overnight, folks. Overnight. This is not something we can wait around for. If you want to wait around, then say goodbye to your country. I'm sorry, I sound like I'm being a little harsh, but when I read a decision like this CMS decision from the United States Supreme Court, it makes me angry. It makes me angry that we don't have the resources that they do to be able to win this, to be able to win more of these fights, take on more of these battles, and stop what's happening in our country immediately today, once and for all. Okay. I don't want to talk too much more about it, but I do want to say just a couple of quick things because a lot of people have asked, basically, who does this apply to? Will this affect me? Do I get to keep my job? Do I still get a religious exemption? Yes. Again, even the CMS mandate, if you're healthcare workers, you still have the right under federal and state law in most cases to apply for religious exemption. If you're denied a religious exemption, you can come to We the Patriots USA and we can talk about trying to find you legal assistance. We are not a law firm. We don't represent you directly, but we can find you an attorney and even try to fund that litigation. That's part of our mission. We are a 501c3 nonprofit, so any donations you make to help fund us, our organization, are tax deductible in most circumstances, though check with your tax preparer. And as far as the OSHA mandate, some people say, well, now the court struck it down, right? So if I work for an employer with 100 or more employees, that means I'm good, right? They can't force me to get the shot, right? No, unfortunately, that's not true. A private organization or any organization, whether it's a government organization or a private organization, can make its own policies in addition. Okay, so now they don't have the cover of saying that, okay, well, the federal government enacted this, Biden enacted this, so we don't have any choice. We have to adhere to it. They can't pass the buck anymore, but they can still take on the buck themselves and say, okay, we are enacting this mandate. We are enacting this federal mandate. It's going into effect, and excuse me, not this federal mandate, this vaccine, this COVID mandate. Private companies can say we're enacting our own. And states can do the same thing. We're enacting our own. So okay, so the federal one is gone, but we're enacting our own. They can still do that. The Supreme Court didn't say that's illegal. They didn't say that's unconstitutional. They just said the federal government can't have this mandate, but it still doesn't stop your private company from enacting it. And that'll have to be litigated too. And that's why we've been taking on more and more lawsuits, like against Bristol Myers Squibb, like against the state of New York over their mandate. Like I mentioned, the PGA Tour, Taryn Gregson's case that'll be filed shortly. These private organizations, we are suing them because we believe that their mandates are illegal, or that the denial of exemptions, I should say, in these cases is illegal. Okay, so we're going to keep fighting. We're not going to stop. That's where we go from here. A lot of people ask, well, where do we go from here? We're going to keep fighting for healthcare workers. We're going to keep fighting in the private sector and the public sector. We're going to keep filing these lawsuits because we need to win this race against the bad precedent. We need to set good precedent before the bad precedent takes hold in our jurisprudence. So without further ado, I'm going to turn it over to some of these questions. Let me just go through them real quick. I haven't been able to read them. I don't have any producer in the background or assistant helping me with this. I'm flying solo tonight, so I'm going to do the best that I can. By the way, for those who don't know me, I'm Brian Festa, co-founder and vice president of We the Patriots USA, Inc., a national nonprofit working to take back our country through the courts, through education, advocacy, basically connecting patriots all across this country to take back what are really our God-given rights. They're not rights even given to us by the Constitution or our founders. They're given to us by God. All right. So someone asked about the masks. So I have a question about masks. The masks have to come off. They make no sense for healthy people. How do we put pressure on the State Board of Education to end this insane policy for school children? Well, we agree with that. There is a lawsuit filed by our sister organization, the Connecticut Freedom Alliance LLC, against the state of Connecticut for school mask lawsuit, which is actually currently pending before the Connecticut Supreme Court. So we have, my business partner and I, Don Jolly, have taken on that battle actually, and that we currently have a case pending. Unfortunately, again, on the science arguments, they're not buying it because the CDC, yes, even though there's conflicting reports from the CDC, even the CDC director admitting that the masks don't work, for instance, against Omicron, regardless of that, because the prevailing medical viewpoint is that the masks are safe and effective, preventing the spread, the transmission of COVID. They're keeping them on, even though the prevailing science does not say that. If you take all the studies together, it does not say that. It says quite the opposite, that they actually don't do anything and that they're harmful to the health. But again, the powers that be, the public health authorities in this country, are saying the opposite, are saying you should still mask up. Sometimes they contradict themselves, like Fauci. They'll say it one day, then say a different thing another day. But the official position, forget about what I said in all those other interviews and how I slipped up and gave a contrary opinion on MSNBC that night. Just listen to what I said on CNN the next night. Their official, talking points, their official policy is that masks should be implemented everywhere. So unfortunately, I think it's gonna be hard to win on the science. Let's see this. Someone asking about the Nuremberg Code. Elaine, thank you for that question. A lot of people talk about that. I want to clear something up. The Nuremberg Code is not actually law. It's not international law. It's not a treaty. The United States did not sign a treaty to that. It's not part of United States law. It's a set of guiding principles that that were crafted in response to obviously what happened, the atrocities that happened in Nazi Germany during the Holocaust, and the Nuremberg trials. You're probably very much familiar with. Anyone who's citing the Nuremberg Code, I'm sure you're familiar with that. But that was never officially adopted as law. So it's not binding law in the United States. So that's how they can ignore it. A lot of people are wondering, well, why are they ignoring it? Why can't they be held to it? Because it's not a law. They don't have to adhere to it. Yes, they are principles to be aspired to, and all of these governments these countries say that they agree with the principles that against human experimentation, for instance, but it hasn't been adopted as law. So it's not something that needs to be followed. One of the first things you learn when you go to law school is this idea of controlling authorities and jurisdiction, and which laws apply to which places, and which states and or local governments, what they have to follow, what they don't have to follow. A lot of people, if you haven't gone to law school, might not understand that. But it's not, just because something might be accepted in one country doesn't mean it has to be accepted in another country. Someone asks, this is a tough question. How do you plan on winning the case for healthcare workers who are told that they have to take the jab or jab to stay employed? Well, again, we stand on religious liberty. We feel that's the best way to win. If that person has a religious objection or even a medical objection, they have a disability, they have a doctor's note saying they can't receive it, and the employer refuses to accommodate that. Both religious and medical discrimination are prohibited by federal law as well as under state law in most cases. When I say medical discrimination, I mean disability discrimination, not really medical discrimination. If you have a disability, if you have a reason because of a disability that you can't receive it, and they refuse to accommodate you, in many cases, that is an actionable claim of discrimination. So that's how we would win those cases. Again, we're not going to win a general challenge to mandates. Look what just happened with the CMS decision. The fact that, the Supreme Court of the United States said that, it's okay, that it's perfectly legal, it's perfectly constitutional to force this mandate on all healthcare workers that receive Medicare, Medicaid funding. That tells you right there, you're not going to win a general challenge to the mandate. If you're not going to win it at the United States Supreme Court, you're not going to win it pretty much anywhere in the federal courts. Again, they didn't technically rule on the merits yet. It was just saying that, the balance of the equities, when you're looking at, all the factors and whether to grant an emergency stay, that they did not feel that those were satisfied. The risks, outweigh the benefits basically of the stay. That the risk to public health would be worse than the risk to these workers if we didn't keep this mandate in place. That's one of the things you have to do. You have to evaluate sort of the balance of the risk, the balance of the harm. Again, we who know the real science know what the truth is. All right. But, unfortunately, they're not going by the real science. They're going by what the talking heads are saying, what the so-called public health authorities are saying. Let's get some more questions coming in here. Carrie, our good friend Carrie Wright, writes in, if a company is going ahead with their mandate despite the ruling and a person is fired, do you think there will be opportunity to sue? So again, not necessarily, because private companies can still enact their own mandates. There's nothing in this decision that says that private companies can't have their own mandates. It's only saying that this particular federal mandate doesn't have to, doesn't hold muster basically right now, and that, this stay can be granted. If the company only had a mandate because of the Biden OSHA mandate and they never had their own private one, now that this is struck down, they should not be going ahead with it. But it doesn't mean that tomorrow or the day after the Supreme Court issued its decision last Thursday, so doesn't mean that last Friday the company couldn't have said, okay, well, now we're creating a new mandate, our own private mandate. That's technically legal. It is legal. There's nothing to stop them from doing that. Again, I think the way that we would win is if they didn't allow exemptions, if they didn't allow religious and medical exemptions. That's the way that we win cases against them. But we're not going to win just a general challenge, say you're not allowed to have a policy simply because the OSHA mandate was struck down. Again, the Supreme Court didn't say that private companies aren't allowed to have mandates for their workers. It just says the federal government couldn't have this broad sweeping mandate. Very different. Okay, let's just look real quick. I've got some more questions by the real light warrior here, but I'm trying to find some other people who haven't asked questions yet and bring their questions in. Let's see. Let's see. Yes. Don't worry about that. Someone's worried about my cough. I actually am recovering from Omicron, but I did it without having to get a jab. And yes, I'm very familiar with Dr. Zelenko's protocol. I'm in touch with Dr. Zelenko and other fine doctors, such as Dr. Peter McCullough, Dr. Pierre Corey, and other people that are friends of mine, actually. That I am well aware of their protocols, and I have been able to recover from 2 bouts. This is my second bout of COVID. I believe I had Delta as well back in September. So, and I've been able to recover without the aid of any kind of jab. All right. Yeah, Peter asked the question, can't you present evidence that vaccines don't work? You can, but again, they're not going to believe it. Because it's not the consensus, because most doctors are saying that's not true, that evidence is faulty, and that the weight of the evidence balances in the favor of vaccines being safe and effective. The problem is they're never really called to the carpet. At least I haven't seen them called to the carpet in a court of law, and asked to actually show that evidence. It's just because they have a title. This is what I've railed against this for years. It's bothered me for years, the fact that in this country, we trust the authority of the person over the authority of the evidence. So if somebody has a fancy title, some credentials after their name, some letters after their name, then they are given supremacy. It doesn't matter whether they have any proof to back up what they're saying. They are given the final word, the final authority, because of their title. That's bothered me for years. But unfortunately, it's the state of it's the state of things in America in this 21st century. Tanya's asking, could there be a case for discrimination against healthcare workers? Again, I've talked about that. We have a case for discrimination against New York State healthcare workers. If you are a healthcare worker and you feel that you are being discriminated against, please contact us, info@wethepatriotsusa.org. If you've been denied a religious exemption or a medical exemption. Again, if you haven't applied for those yet, we really couldn't step in. It's not the time for us to assist you yet, because I talk to a lot of people about this. They say, well, I just want to challenge the mandate. I just don't think the mandate should even exist. I haven't been denied anything yet, but I want to get the ball rolling and file a lawsuit right now. Well, you can't do that because you don't have standing to sue yet. What do I mean by that? So in order to prove standing, again, this is like first year law school, we learn about standing in court. Standing means that you've been harmed. You've suffered a legally, judicially cognizable injury, they call it, an injury in fact, that you've actually been harmed by it. All right. If you haven't even asked for an exemption yet, how have you been harmed by a mandate? The judge is going to, first question you're going to be asked, well, have you asked for an exemption? No. Okay, case dismissed. Come back to me when you ask and you're actually denied. All right. You haven't actually lost anything unless you've been told that you can't be exempt. You haven't even tried to get an exemption yet. You don't have standing to sue. So please don't contact us if you haven't requested any exemptions. If you just want to challenge a mandate generally, those lawsuits aren't going to win. So we're not going to take them up. I mean, people, again, might get upset about that and think that we should be challenging them. We have very limited resources, very limited funding. We cannot afford to be spending it on cases that we know almost certainly are going to be losing cases. 99% chance of being tossed. I'm not going to invest $50,000 to $100,000 in a lawsuit that I know full well as an attorney myself is almost guaranteed of being dismissed. It's just, I'm not going to do it. I'm not going to do it because that's a waste of our donor resources. I'm going to spend the money where I know there's a very good chance we're going to win this lawsuit. And it's going to set precedent nationwide. I have to be wise. I have to use my discretion, my years of experience as an attorney, knowing the law, reading other cases from across the country and the United States Supreme Court, and knowing how they're likely to rule. I have to use my discretion of what cases to bring. I can't just willy-nilly bring every case that somebody wants to bring just because they're mad and they want to fight the mandates. I have to use discretion. So again, it's not that we don't care about other people who aren't in that situation yet, but we have thousands of people contacting us from around the country who have already lost their jobs, who have been without a paycheck for months now, and they need help. And they have to take the priority over someone who just wants to bring a challenge when they haven't even been fired yet or haven't even been denied an exemption yet. So unfortunately, we can't help everyone, but we have to be very selective about those cases. That New York healthcare workers case is huge. If we end up winning that case at the United States Supreme Court, that will apply everywhere to say that you must provide religious exemptions. You must offer them to healthcare workers everywhere in the country. States like New York, states like Maine, Rhode Island have enacted mandates denying them, blanketly denying them, saying you can't even ask for a religious exemption if you're a healthcare worker. And that is, in our view, patently unconstitutional and illegal also under Title VII of the Civil Rights Act. All right. Jennifer, case in point. My hospital accepted religious and medical exemptions, but denied all of them. So they allowed you to ask for them, I think is what she's saying, but denied everyone's. Okay? Illegal. You can't just decide that it's an undue burden, for instance, for everyone to be granted an exemption. That's the reason that they usually blanketly deny all of them, is they usually say, well, it would be an undue hardship, an undue burden. So under federal law, if it's more under Title VII, as I just mentioned, if it's anything more than a de minimis or a minimal burden on the employer, they're allowed to deny it. And so some of these facilities have decided that for anyone to get an exemption would be more than a de minimis burden. But that's really not true, because there's people, for instance, that work in hospital administration that have nothing to do with patient care. Okay. And if you believe that masks work so well and these N95s work so well at preventing the spread of this bioweapon, then even if they do have to pass down a hallway occasionally where there might be some patients present, wear the mask, wear your PPE. You've said for the last 2 years that works so well in preventing. All these public health authorities have said that it works so well in preventing the spread, the transmission of this bioweapon. Then why don't you allow? Now suddenly it doesn't work in the workplace. Now just because we have shots, now it doesn't work. So someone, for instance, that works in the business office, who really doesn't have any, very, very minimal, if ever, has any connection with a patient. Some of them even working remotely. You're going to tell me a medical coding specialist who's working 100% remote at home, that's an undue burden for you to give them an exemption? BS. It's not. And if we have some of those people, if you're one of those people working fully remote or minimal patient contact, those are going to be the strongest cases, because that's going to prove right away that your idea of this undue burden is completely unjustified and falsified. You didn't do that case-specific analysis that's required in Title VII. You have to look at each case on a case-by-case basis, the facts and circumstances, and decide whether you can reasonably accommodate them or not, and whether it would be an undue burden more than a de minimis burden on the employer. You can't just blankly decide that it's more than a de minimis burden for everyone without even looking at the individual job specs and the situation and how much they have contact with patients or something like that. For the people that do have direct care and are in patient care every day, those are going to be harder cases. But even still, I think we can win a lot of those, because you have all this PPE, you wear the gowns, you wear the N95s, you wear goggles, you wear, you're head to toe, you're covered with PPE. I've talked to people in healthcare who work in hospitals, and they've told me this. Especially when you're working with COVID positive patients, but even without that, now that there's PPE. A lot of hospitals, you have to wear an N95 all the time, regardless of who you're dealing with, gloves, everything. So if these PPE work so well, and they worked so well prior to the shots being available, how can you all of a sudden now say, well, no, it would be too much of a burden to just use PPE? And especially now, it's undercut by the fact that now the CDC has said, well, if you've gotten the jab, even if you're COVID positive, as long as you don't have any symptoms, you can come back to work. Even if you're COVID positive, you can come back to work before you've even fully recovered, before your quarantine period or something. You can be COVID positive. You can have the active virus, whatever, inside of you, be COVID positive, and still allowed to work as long as you've had a jab. But there's absolutely the problem with that. As I said earlier on the Steve Day show today, I was on Steve's show on Blaze TV. Check it out. Hour number 2, I came on to talk about a couple cases that we're involved in. But if you're COVID positive, somehow there's less of a chance, even if just because you're jabbed, there's less of a chance of you transmitting it to someone. But there's no science that says it. That's the problem. And Governor Ron DeSantis, Florida, was saying this the other day in a press conference, that this doesn't make any sense. So now you've thrown all these other workers out of work who were healthy. You're saying they can't work. They're healthy. They're not COVID positive. They have no symptoms. Just because they're not jabbed, they can't work with patients with PPE and everything. They can't do it. But someone who's actively COVID positive, just because they received the shot previously and their boosters and whatever, they can continue to work with patients. Makes no sense. And it proves this isn't about public health. This is a political agenda, and there's a larger agenda from the pharmaceutical industries. There's a lot of money flowing between the pharmaceutical industries and the government. There's a lot more going on here than public health. This is not about public health. Because if it were, none of these mandates would exist. It doesn't add up. There's no science to support them. Okay, so anyway, that was a long answer to your question. I went off on a little bit of a tangent. I'm sorry about that. Some people have asked about, I saw a question up there earlier. I'm sorry I didn't put it up, about the federal contractor or federal employee mandate, which was separate from the Osha mandate. No, this decision didn't have an effect on that. Unfortunately, we still have to see how that pans out. And I know there's been a lot of people that are affected by that and that are angry about that, because a federal contractor is not just someone who has some major federal contract. Any kind of government money at all coming into the business is considered a federal contractor for the purposes of that rule. So, but again, it really doesn't matter if these businesses wanted to enact it, which most of them, unfortunately do. They can have their own private mandate. So even if that mandate goes away tomorrow, these private companies can. This is why we have to keep fighting. We didn't just win everything on last Thursday. All right, we have to keep fighting. So a lot of people have asked this question since the shots became widely available over the last year. People have asked, will the employer then be liable for adverse reaction or injury? The answer is yes, yes, and no. So they will be under the Workers' Compensation Act of that particular state, whatever state they're in. In most cases, they will be liable, but they won't have full liability that you would have in court, because the Workers' Compensation Act is a limited liability recovery system. It offers you wage replacement. It doesn't offer you things like emotional distress damages. It doesn't offer you, punitive damages, other things you can get in court. You're not going to pay your attorney's fees in most cases, but it is going to give you the wage replacement. So if you've lost wages, if there's been injury or death, and that person now has lost wages for however long of their career that they would have had, by reasonable estimates, you can get wage replacement for that. So you can recover lost wages that you would have gotten because you're out of work now because of that. So you can recover that, but it's minimal recovery compared to what you'd get in court for like a wrongful death suit, millions of dollars or something like that. You're not going to get that through workers' compensation. So yes, any job-related injury in most cases is, does trigger liability under the State Workers' Compensation Act, but unfortunately, that's going to be limited liability. It's not going to be this huge amount of millions of dollars per person. You're just not going to get that. And so what will happen is if enough claims are filed, especially with a large employer, their insurance, workers' compensation insurance premiums can go up. And then eventually they could even risk losing their coverage if they have too many claims. But that would be way down the line. That's not happening anytime in the immediate future. And quite frankly, most of these employers don't believe it's going to happen because they believe the shots are completely safe and effective. So they think all of these allegations about supposed dangers, and risks, they think that's a bunch of bull, and that, and their attorneys probably are telling them that too. I don't know, but they probably are telling them that too. Don't worry about it. That's unlikely to happen. Nobody really gets injured from this shot. Because that's what the mainstream believes. And so most of these people who are giving us advice are mainstream, unfortunately. Somebody's asking about testing. Leslie's asking, my employer went the route of testing instead of mandatory vax public school. Assuming she's saying she works in a public school. Is there any argument to be made against the testing? Possibly. Again, I hate to give these sort of lawyer questions. It depends, is what we also learned in law school. That's the classic lawyer response. It depends, maybe. So if it's totally unreasonable, if you have to pay for your own testing and it's like $200 per test out of pocket every week or twice a week, and you have to use your own time to get the testing too, and all this, if there's a big burden on you, possibly, you could make the argument, especially if you're in a public school and you're a member of a union, which I'm assuming you probably are if you're a teacher or a staff member. Not 100%. It doesn't always apply to public school employees, but you probably are a member of a union. You can try to take it up with a union grievance. Unfortunately, many of the unions are not being supportive of our position. They're supportive of the school's positions. So that's going to be tough, but you can possibly make an argument, since you objected, maybe I'm guessing maybe based on based on your religious belief, or you're saying, oh no, you're saying in this situation you didn't even get a shot mandate. It was just we're just going to test everyone if you're not jabbed, I'm assuming. Again, that's hard to make a religious discrimination argument in those cases, because it's not like you made a religious objection and now you're being subjected to this burden because of your religious beliefs. It's anyone who doesn't have the jab, whether it's for medical reasons, religious reasons, and any religion, whether you're Catholic, whether you're Jewish, whether you're Muslim, any religion, you have to, if you don't have the jab, you have to get tested. So it's not really religious discrimination. It's not really medical discrimination. It's just vaccination status discrimination, which isn't a protected class under any state law, to my knowledge, and certainly not under federal law. There's no vaccination status. Like, how there's a prohibition against discrimination based on race, color, national origin, sex, religion, obviously. But there's no protection for vaccination status. So those cases are going to be really hard to win. We do have one testing case, though. I mentioned it already tonight. Taryn Gregson the PGA Tour employee, who's the host of a wonderful podcast we have called Faithful Freedom with Taryn Gregson. It airs usually every Wednesday. So tune in. You can find it on Spotify, on Apple Podcasts, on a variety, basically almost everywhere where you find podcasts. Look up also our YouTube channel and her YouTube channel. You can find it everywhere pretty much. Faithful Freedom with Taryn Gregson. We are so lucky to have her. She's a consummate professional and just really, really knowledgeable about this stuff. And she's a fierce fighter for freedom. She herself was fired by the PGA Tour for refusing the masking and testing mandates. So she has a religious objection to both, and she refused them, and she was fired because of it after years of very, very high level of service to the tour. Her ratings were great. She did a great job. She had been working in a home studio for 19 months and then suddenly was told that wasn't okay. And this all while she was 22 weeks pregnant, okay, with her second child. We're going to be filing that lawsuit very soon. She's in Florida, so that's going to be filed. That's where the tour is as well. That's going to be filed in federal court in Florida. So look out for that. And please help us help Taryn. Donate to wethepatriotsusa.org. And, all of this goes to our organization and our litigation efforts as well, such as the Taryn Gregson case. But that is our first testing and masking case. We feel the facts are very favorable in this case to her. So it has some unique facts, that we don't see in a lot of other cases. So it's not to say we'll never take up a masking or testing case, because obviously I've just mentioned tonight 2 of them, that we've been involved in one way or another. But they're harder cases. I'll admit that they are harder. Okay. Let's see. All right. Elaine said, thank you for discussing Nuremberg Code not being law, etc. Are mandates a law? Well, again, that depends. If they're enacted, properly, and they allow for exclusions and allow people to opt out, then I believe that there is that they would withstand judicial scrutiny as a law if they're actually passed as such. Congress hasn't passed mandates. State governments, in most cases, to my knowledge, have not passed mandates. This has been all executive orders. Executive orders are not laws. Executive orders, especially where the legislatures of those states haven't granted specific authority to the governor to enact certain orders, those are not legal even. Where they have granted the authority, they may run afoul of the Constitution. So again, it depends. I have to see what the mandate is. Is the mandate everyone needs to get a shot? Everyone in the whole entire state needs to get the shot and needs to get all the boosters, and there's no religious or medical exemptions allowed? That's clearly not legal. Could it be passed as a law by a state legislature or by Congress? Sure, it could be passed, but I believe it would be struck down. But a mandate just by executive order without authority from Congress, without authority from a state legislature, should not, in my opinion, be treated as the law. Do courts treat them as the law very often? Yes. And that's why we have to keep fighting, folks. That's why we need the funding. We need to keep on fighting. Let's see what else I have here. Jennifer's asking, why are hospitals denying religious and medical exemptions? Is this legal? Do you mean for employees or do you mean for patients as well? Because we have some cases there. I already talked about the employment cases, but we have cases actually where we have some cases we're exploring right now, bringing on behalf of people that are trying to get organ transplants and are being told that they can't because they're not jabbed. We believe that's illegal. And so we intend to fight for them. But yeah, that's a big problem too. So look out for those cases as well. We're still in the exploratory stages and we need funding. Again, that's always the thing. We can have great legal claims and great plaintiffs and great attorneys, but then when we look at our bank account and realize we don't have enough to fund all these cases and run our organization, it becomes very difficult we're very limited as to what we can do. And that's why we need some more donors to step up for us. Peter asks, what about natural immunity? How can a company force you to get vaccinated to create immunity if you already have it? Because they don't believe in natural immunity, Peter. Again, are the talking heads saying that a natural immunity is just as good as jab-induced immunity? Have you heard the CDC director or Anthony Fauci say that yet? No, you haven't. Why not? Why not? Because there's no money in natural immunity, Peter. There's no money in it. And they can't control you with natural immunity, Peter. They're not going to give you a natural immunity passport. They'll give you what they call a vaccine passport, but they're not going to give you a natural immunity passport to get into restaurants and entertainment facilities and things like that, because they don't care about natural immunity. They don't believe in it, even though they know it exists. They're denying that it exists, or if it does exist, it only exists for 3 months. They say 90 days. That's the talking point. That even if you get natural immunity, it's temporary. Whereas these shots, they're going to last forever. Oh, except that now you need a 7th booster. But that's forever. But that's going to be forever until you need the 8th and the 9th booster, and so on and so forth. We know this is a game, Peter. We know this is garbage. These are talking points. We know this is a political agenda. This is a globalist elite agenda, a globalist cabal agenda. We know this. We know this. It's very, very clear. All right. The evidence is right there, hiding in plain sight, as they say. But unfortunately, it's being ignored. We'll keep fighting, though. Again, that's what I keep ending with. We're going to keep fighting. Becky asks, what about states where both exemptions have been taken away? Connecticut just ditched the religious exemption last year. Yes, they did for school children you're referring to. That has nothing to do with employment, though. They said school children can no longer, except the ones that they grandfathered, the 8,500 some odd students that they grandfathered during the supposed public health emergency. And by the way, we're appealing that decision as well from the federal court, District Court of Connecticut. We're appealing that to the Second Circuit because we have a federal lawsuit against the state of Connecticut for taking that religious exemption away from school children. It's another one of our major lawsuits in federal court. That was for school children. They ditched the religious exemption and said school children from now on, except for the ones that grandfathered, will not be able to seek religious exemption anymore. So that doesn't have any impact on employment, though. All right. Employment mandates Title VII still exists. Connecticut can't repeal Title VII and say no more religious accommodations in the workplace. You can't do that because federal law preempts a state law to the contrary. All right. So even if Connecticut passed a law like that, it would be preempted by federal law. As long as Title VII is still on the books and says, you have to allow reasonable accommodations for religion, for religious practice in the workplaces, they still will exist in the workplaces. But they don't have to exist in school because there's no federal law that says you have to give religious exemptions in school, except for the Constitution, which is the supreme law of the land, as we're also taught in law school. Again, this is a Law School 101 tonight. I'm walking you through my first year in law school. The Constitution is the supreme law of the land, okay? And the First Amendment does say that there's a freedom to exercise one's religion. The government has to respect that. Well, guess what? Public schools are government agents, are government entities. So they do have to respect it. So there is the federal law of the Constitution. There's no Civil Rights Act specific to, allowing religious exemptions for vaccinations, for immunizations in public schools. There's no specific law about immunizations, but there is the law against religious discrimination, which is in the First Amendment, and that is supreme. So that is and there's the 14th Amendment as well. There's other arguments that we're making, Equal Protection Clause arguments as well. There's a lot of arguments we're making in that case, but the First Amendment is chief among them. All right. And so we will continue to fight. That's the theme for tonight. Yeah, Sean's relating a horrible story of someone. He knows whose friend now has to have the liquid around her heart drained on a regular basis since getting the shot. I'm assuming he's referring to pericarditis, the lining around the heart. Maybe myocarditis. This happens as well sometimes where there's a fluid buildup and it has to be drained. I'm hearing reports of myocarditis in young people that's, at rates that's never been seen before. Don't believe the lies that some of these politicians will try to tell you, or some of these public health figures, these talking heads will try to tell you that, oh no, the rate of myocarditis is no different from normal. Well, no, because I'm talking to doctors and a pediatrician just the other day. Taryn interviewed him. Dr. Paul Thomas has said in all of his 35 years of practice, a busy pediatric practice, thousands and thousands of patients, he never saw a single case of myocarditis. And then immediately when this was approved for children or for young people, he saw his first case and someone having to be rushed to the emergency room after getting the shot. So don't tell me. And the risk is 4 to 6 times greater of being hospitalized from myocarditis than it is from being hospitalized by the COVID infection itself. He says that. Go back and watch Taryn's interview with Dr. Paul Thomas. You'll see that. Again, Faithful Freedom with Taryn Gregson. Rosemary asked about the religious exemption in Connecticut update, and I just gave you an update for that. So I think I answered your question. You can check back on our website and subscribe to our email list if you'd like more updates. Also, Telegram. We have a great Telegram channel that's run by my amazing business partner, Don Jolly, whom I've already mentioned. It's t.me/We the Patriots USA, or you can just look it up, We the Patriots USA on Telegram. Please join that. We have great updates, from all across the world, things that are going on with related to COVID and otherwise. Freedom of religion, this critical race theory. We just announced a big lawsuit we're taking on today against Guilford Public Schools for critical race theory. There's so much that we're doing. It's such important work, but we really, really need your support. WeThePatriotsUSA.org. You can click on the donate tab. Please consider a donation, or let other people that about the important work that we're doing, and help us to fully fund our organization so we can be a well-oiled machine against this tyranny. We have a saying at We the Patriots USA: when you stand up to tyrants, we stand up for you. So let's look at this. See if I have anyone else that hasn't weighed in. A lot of multiple questions. I'm sorry I can't answer them all because I have limited time. I'd be on here all night. Yeah, Clarissa, this pains me. You went from a hero to a zero. I'm saying this so much over and over and over again. Yep. Suddenly now, just because you won't submit to their tyranny and roll up your sleeve and bow to them, you're nothing. You're not worth anything. You're dispensable. Again, you're looking for contact info, Clarissa. It's info@wethepatriotsusa.org. Info@wethepatriotsusa.org. Someone's asking about our case against Bristol Myers Squibb. Jim's asking, once the results of the case are determined, will the employees who were terminated after denial of religious exemption be covered if they were not part of the original suit? It depends on how broad. Again, I hate saying over and over again, it depends, but it really does. It depends on how broad the court's ruling is. If you look at our complaint, we asked for it to apply to not only the named plaintiffs, but to all similarly situated employees, excuse me. If the court chooses to narrow it, though, only to those named plaintiffs, then unfortunately we won't have a broad ruling. If they give us what we asked for in our prayer for relief and ask for it to apply to anyone who is similarly situated, then yes, it will apply if the court makes it broad enough. So it's really up to the court. I can't guarantee that it'll cover every single employee situation. But that's what we're going to ask for. That's what we have asked for. If you read our pleadings, we've asked for it to apply to everyone. Unfortunately, lawsuits are not quick, so we won't have a decision immediately. Um, let's see. Just trying to see anyone else who might not have asked a question. If a company who profits financially, Janelle asks, if a company who profits financially, or is that Janie? I'm sorry, I think it might be Janie. If a company who profits financially from the shots requires employees to get them, isn't that a conflict of interest? Can they be sued for that conflict of interest? If there's a direct benefit, I mean, all healthcare facilities, for instance, are getting funding because or have their funding tied to the CMS mandate. And so in that way, they're being forced, basically coerced by the federal government to have all their employees get the jab. Are you talking about like a pharmaceutical company? That might be a different story. The pharmaceutical company is directly benefiting, obviously, if they're the ones that produced it. So, for instance, Pfizer, Moderna, Johnson & Johnson, if they actually produce the shots and are requiring their employees to get them, is that a conflict of interest? It's going to be hard to make that argument, considering that pretty much every company, every large company, especially in the country, is mandating these shots. So it's not like only the pharmaceutical companies are mandating it for their own employees. It's generally accepted as a public health measure as well. And they may be offering them free to their employees. My hunch, I don't know for a fact, my hunch is they probably are. So if they're offering them for free, how are they making money by offering them for free to their employees? And the only ones where it would be a direct conflict of interest would be the pharmaceutical companies that actually manufacture them. So I don't really see a claim there. It's one thing for government officials to be involved in that kind of a legal conflict of interest. It's much harder with a private entity to prove there's any kind of illegal conduct there. I'm sorry about this. I'm talking too much, so I'm getting a tickle, and I don't have a drink right beside me, which was not wise. I usually do. This is automatically recorded by StreamYard. Somebody's asking, is this being recorded? Becky's asking. It is. It is going to be publicly available as well on our on our Facebook and Twitter pages. You'll be able to find it, as well as our YouTube page. And we will have a recording available, and I'll try to get this posted to our website as well, to make sure that other people can watch this later. I think that would be a good idea. So StreamYard does automatically record these things. That's the software that we use called StreamYard. So there is a recording being produced as we speak. I will capture that recording, download it, and have it uploaded to our website and our Rumble page, as well as our YouTube page. And like I said, it'll be on our Facebook and Twitter pages until they censor us and take it down. But you can find it by hopping on those as well. And we'll share it in the Telegram. Once we have a link and we have a recording of it, we'll share it in our Telegram channel as well. So that's pretty much it for tonight. I'm going to wrap this up. It's been great. Like I said, I'm losing my my voice here. So, unfortunately, I can't take everybody's questions. I would have liked to stay longer to take more questions, but I think if these things are too long, sometimes that works against you too. People don't want to watch. They see a video that comes up and it's an hour and a half, 2 hours long. We're already creeping up on an hour and a half. So I'm going to end it for tonight, but I want people to keep coming in with questions. If you have questions, put them in the comments. We'll do our best to respond. Also, be sure to subscribe to our channels, to like this video, to share this video, and to please consider a donation to We the Patriots USA. Again, you can go to wethepatriotsusa.org. Go to our homepage. Right at the top, there's a donate tab, and you can choose either a single donation or a monthly donation. Both are appreciated, especially monthlies, because this work ain't stopping, folks. We have so many new cases coming in and such limited resources to take them all on. Getting, again, requests from thousands of people all across the country. We really need to increase the funding. That's the bottom line. it all comes down to money. I hate talking about money all the time. I wish I didn't have to talk about it. I wish I was independently wealthy and could just fund it all myself, but unfortunately, I'm not. So the reality is, until we get the dollars in, it's not going to happen. We're not going to be able to take on all these cases. We're not going to be able to defend all of your rights. It does come down to money. Litigation is extremely expensive. One case, like I said, can be $50,000 to $100,000 or more. When you're talking about our goal of filing dozens of cases in each and every circuit of this country, that's extremely expensive. You're talking about not just seven figures one time over, but many, many times over in order to do this the right way. And we need a staff to manage it all. For the most part, we're a group of volunteers. We really don't have a staff per se. We have one full-time employee right now, and that's it. We don't I don't even take a salary from We the Patriots USA, nor does my business partner Don. We hope to change that, because we do want to commit full-time attention to this organization, to run the organization, but we can't right now. The money is just not there, and that's to our detriment. That's holding us back from realizing our full potential and really being this litigation machine and this education and advocacy machine that we want to be. Please consider supporting us. We are a tax-exempt organization, a 501c3 nonprofit organization. So again, in most cases, gifts are deductible on your taxes. So please consider a contribution. If you'd like to make a major financial contribution, if you have the means to do that, please contact us at info@wethepatriotsusa.org. Or if you know someone that might have the means to, put them in touch with us, and we can start a private conversation about how that would work and setting that up. Otherwise, we have an address where you can send a check. On our website, our mailing address is posted, and then of course on our donate page, we have all the different electronic donation options, from PayPal and Venmo all the way to Stripe, private conservative platform called Cornerstone or Line Pay. We have all the different options for whatever you're most comfortable with. So again, thank you tonight for your time, for your attention. It was my pleasure to do this. I hope it was informative. I hope you got a lot out of it, and I look forward to talking to you all again soon. God bless you.